May it please your lordships. Lord, may I once again request your lordship to revisit Berubari for a minute. Lord, where we had stopped yesterday. Lord, that is PDF, Lord, volume 13, page 492, at 508, para 31. Volume 13, 492, at 508, para 13. 31, sorry, para 31.
PDF 508.
Sorry, my lord?
PDF 508.
Yes, ma'am.
So the way PDF number?
Volume 13, page 492, at 508, para 31. Which I read. I'm
Yes,
just
you read
wanting
it, yes.
one line to be read again, to buttress my point.
508.
Lordships may see last 10 lines of that para 31. Last 10 lines. That's not very crucial because that's exactly what has happened. 370 is a clear, I would say, reflection of this viewpoint that 8 justices of this court have taken.
Running page 6038.
My lords have got it?
1 minute, my 6038. running page.
Where is the young intern?
We are also in the same.
I know, but there was a young intern who was helping Justice Call here.
At least
I
I'm
don't
trying
see
to
the
do it.
young
myself. Justice Kaul and me are totally newcomers to this.
Beware of my lordship justice. He doesn't appreciate those of us who are technologically challenged.
So they've become pros now. My two brothers have become pros. Brother Suryakant, I had indoctrinated when we sat together for 2 years. We were together on the
So learning experience even yesterday evening while going home.
Yeah, my Lord Justice Khanna would remember Delhi High Court started it much earlier. That's why those judges from Delhi High Court are extremely professional.
We've been used to it.
Yes.
Been used to it. I think for regular matters, I found it to be extremely helpful. It's very convenient.
I escaped it.
See, some state governments are very supportive. Others, are. I remember the time of the pandemic. I won't name the High Court. They didn't have money to pay for the licenses for this video platform that we were in. So dust cheap. We just withdrew some licenses from the Supreme Court and transferred it to them because they were absolutely in a dire state. And at that time, there was a lockdown. It was impossible to run the court without video conferencing.
But if your lordships can carry this into the lowest of the courts, Mofizil courts, it would be the greatest contribution that your lordships will end up.
Phase 3, we have a huge budget, so we are in the process of doing that, setting up our own cloud software for video conferencing.
And your lordships, there will be at least continuity since all your lordships are here for at least next several years. So, now last 10 lines of this para. This power it may be added. The words this power it may be added. My lords have it?
Yes.
This power it may be added is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question as to how treaties can be made by a sovereign state in regard to a cession of national territory and how treaties when made can be implemented would be governed by the provisions in the constitution of the country. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution and subject to the limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on provisions of the constitution itself. Number one, in my respectful submission, the treaty in question here between the erstwhile ruler and the Governor General, which ultimately, that has now been transfixed into Article 370. So, 370 is an extraordinarily unusual provision. It's never, it's something which is so beautiful that, the constitutional framers felt that how do we give, a kind of respect, kind of acceptability, kind of, validity to this, letter of accession. So they devised, as I said yesterday, it was an absolute brilliant statesmanship on their part to bring that into constitution to assure people of Jammu and Kashmir that we mean what we say. We are not going to do away with this. So, my lord, that's why, my lord, this is very important that treaty will have to be interpreted in the light of 370. It's now, my lord, virtually, my lord, transposed into Article 370. Now, my lord, in the light of this discussion, please see, my lord, at page para. Therefore, our conclusion is para 44, my lord. Page 515, para 44, just first sentence. And this becomes even more important now. Therefore, our conclusion is, and Lord, in my respectful submission, Lord, no, it's a view which is, Lord, inescapable, and Lord, it binds your Lordship, since, Lord, this is a judgment of a bench of 8 learned judges. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purpose of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that law necessary to implement the agreement has to be passed under 368. Now, concession follows the conclusion. So, my lord, it can't be said that it is on a concession. The conclusion of your lordship is very categorical that legislative power is not possible. Only a constituent power can be exercised in respect of this. And that constituent power is under 368. So, Lord, in my respectful submission, far from President exercising the powers, and I will show, Lord, why President had become functus officio. But, Lord, even assuming that, Lord, 373 survives, which it doesn't in my respectful submission, even then, Lord, the power could only be exercised under the constituent power. No other way. Now, Lord, please. Yeah. Okay. Yes. Lord, this is a little important because your lordship rightly, Lord, raised the issue as to, Lord, the definition of union territories in Article 3. Lord, originally it was not there. It was brought subsequently by, I think, 17th Amendment to the Constitution. But your lordship said states do not include territories. Kindly see that. Page 516, paragraph 47. It would not be out of place to mention one more point before we formulate our opinion on questions referred to us. We have already noticed that under the proviso to Article 3 of the Constitution, it is prescribed that where proposal contained in bill affects the area, boundaries or name of any of the states, the bill has to be referred by the President to the legislature of that state for its use. Therefore, within such period, it is prescribed, it has been heard before us, so and so. Then, my lord, no, I'm sorry. I'm sorry. I missed that page. It's earlier page. It is significant that Article 3. It is significant that Article 3 page 513. My apologies. Sincere apologies. Page 513, para 40. My sincere apologies. It is significant that Article 3 in terms does not refer to the union territories. And so, whether or not they are included in the last clause of Article 3A, there is no doubt they are outside the purview of Article 3B, C, D, and E. In other words, if an increase or diminution in the areas of the union territories is contemplated, or alienation of their boundaries or names is proposed, it cannot be effected by law relatable to Article 3. This position would be of considerable assistance in interpreting Article 3C. So, Lord, Parliament then, Lord, amended, and 18th Amendment. That's the joy of having somebody like Lord Gopal sitting next to us. I must, my lord, confess to your lordships that I have sufficiently been instructed, briefed, and educated by Mr. Prashant Bhushan in this matter over several, my lord, sessions. So because, my lord, he is appearing with me, and So, my lord, it's something which I must not say that it is. Now, my lord, please turn back to that para that I was reading, para 47 at 516. And your lordships will find in the middle somewhere on the other hand, which is that 10th line from the top, on the other hand. Page 516, para 47, in the middle somewhere, or 10th line from the top. On the other hand, it is clear that if the law in regard to implementation of the agreement is to be passed under Article 368, it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house, and that is a safeguard provided by the article in matters of this kind. Please see the language. But this is the protection your lordships have extended, and I beseech your lordships to extend it further.
Constitutional.
Beseech your lordships to extend this further. That this is how you can't, Lord, resort to, Lord, some kind of executive power, authorize president to do this, Lord, do away with everything that Article 3 provides in the garb of, Lord, 356 powers. It makes complete mockery of constitutional safeguards. Because your lordship knows what majorities can do. We have seen, Lord, what happened in 1975. So, Lord, this is the check, and that's why, Lord, constitutionalism, your lordship's, Lord, duty to, Lord, the constitution, to, Lord, ensure that it is upheld by the executive and parliament in letter and spirit. If they don't do it in letter and spirit, this court will strike it down and must. So, Lord, these words, Lord, I now see answers, Lord, to the reference which was sent by the Honorable President. We would accordingly
Really,
answer.
everybody was decided at a time when explanation 1 and explanation 2 were not on the constitutional.
They came as a consequence. Your lordship said,
They came as a consequence of Berubari
correct,
to take into account what the court held, that the state would not include a
Correct.
union territory.
correct.
So now really that issue will not survive because the whole basis was that state will not include the union territory. And therefore, you couldn't see that territory in exercise
Yeah.
of the lawmaking power under Article 3. You had to amend the constitution.
That's what there are two submissions on this. One, that treaty to be interpreted in the light of what constitution provides in respect of that treaty. And two, that if you want to now touch that treaty, you cannot do it by a legislative act. You have to do it in exercise of a constituent power. As I said, Lord, constitution is durable. Lord, if it served the need of the hour on that day, doesn't mean that, Lord, that need must be wished away because you have a majority need. Lord, in my respectful submission, the argument that Lord government is advancing before Lordships, Lord, does not bear out from plain reading of the constitutional provision. Now see, my Lord, chapter 21, the title, temporary, transitional and special provisions. Now, my Lord, I accept that 370 is temporary because it's titled temporary.
Yes.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice, and I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's plot, a very express statement before the Constituent Assembly. So, Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade, Lord, citizens of a state, a country, at that time an independent state, to cede to you. They agree to session on clear understanding.
There is a question of persuasion by.
Sorry.
It was the Raja Hari Singh who requested the government of India that time.
I agree. No question about it.
No, you are
But
saying
the
that
conditions, historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mr. Sibal argued that after 1954, this 370 has become a permanent
Yes.
feature of the Constitution.
Now just see, Lord. Just see, Lord, 370. Lord, 370 is, Lord, what? Lord, first and foremost, 370 is, Lord, that, Lord, Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state. Meaning thereby, all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. We have to begin journey of 370 with that. Then, Lord, they go forward and say in Article, Lord, B, power of Parliament, in Article B2, just a second, in Article, Lord, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, my Lord, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President subject to this exercise of power under D. And read with the proviso. Provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside an instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, the constitutional provisions are now added by 1C and 1D. Legislative powers are added by 371A. 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in union list and the concurrent list which in consultation with government of state are declared by President to correspond to matters specified in instrument of accession, governing accession of state to the dominion of India as matters with respect to which dominion legislature may make laws for that. And 2, such other matters in the said list as with the concurrence of government of state President may by order specify. Now, my lord, why is it temporary? Please see sub-article 2. Please see sub-article 2. If concurrence of government of state referred to in para 2 of subclause B, that is legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing Constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision. So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, my lord, President may exercise powers in consultation with the state government under 1B or my lord 1C or 1D. They said, yes, they can. But you place them before Constituent Assembly for a post facto approval. So, my lord, it was never intended to be permanent. It is a temporary provision. And my lord, the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This is a constitutional provision. President can't exercise powers like this and say 370 is now otiose or it stands repealed or it stands withdrawn. Now, in that context, please see Article 3, my lord, sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So, my lord, he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications, and from such date as he may specify. So, my lord, the power is both for President to continue or President to discontinue. Lord, if he wants to continue, he can continue in same fashion or with such exceptions and modification. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So, Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by therefore an exercise which brought a temporary provision, but temporary in terms of the objects, temporary in terms of the actions to be taken, not by efflux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Lord, Constituent Assembly, as your lordships have been told, Lord, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued Lord CO in 1954. End of the matter. Where does he then have power to re-exercise that role? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened, but now Governor can send in and we can act on it. But that will be virtually not destroying this very express provision. And I respectfully submit that it is impossible to exceed to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article has lived its life, has achieved its purpose. Now 371 survives because tomorrow a constitution is amended and new article is inserted, which we would like to apply to Jammu and Kashmir also. President then seeks the government's view and then extends the article. So to that limited extent, perhaps this article 371 may be necessary. But 373 is very clear that applicability of Constitution of India per se was only in terms of Article 373. And once they decide that, then no, it is untouchable. It cannot be revisited. President became functus officio in 1954 so far as 373 is concerned. And your lordships have expressly accepted this position. In Premnath and Sampath Kumar, both your lordships have accepted this interpretation. I'll make it good to your lordships. Expressly, your lordships have said that. And that is the view. Now just turn to the view of Gopalaswamy Iyengar. As your lordships would recall, Gopalaswamy Iyengar was the Diwan or Prime Minister of Jammu and Kashmir for many years. He was later defense minister in post-independent India and one of the most respected Indians at that point of time. He was heading this. Now just see his page, PDF page. Which volume? Volume 8, PDF page 1175.
The documents. The document file? Document file.
What file? Documents volume 8.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
That's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been applicable.
But if you see the proviso to D refers to other provisions of the constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the constitution require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders, progressively modifying the provisions of the Constitution in relation to the state of Jammu and Kashmir. Which means that, really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life, and what is a temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of us, of any constitutional orders being issued progressively from 1954 onwards, or
Article
1958 thereafter.
refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But subsequently, once the Constituent Assembly goes, whatever, my respectful.
But then where is the power to alter the constitution at all?
Lord.
If your argument is right,
Lord.
then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the constitution in relation to the state of
No.
Jammu and Kashmir,
I respectfully.
which is contrary to what everyone accepted that
373 is only in respect of continuation of 370 or not. Now, they agree, Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes some kind of a permanent decision. Please permit me to reread that 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause D shall be necessary before President issues such a notification. So, Lord, idea is that you had to decide as a Constituent Assembly whether you want this relationship to continue or not. So, Lord, they took that decision.
No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to Clause 3 uses the expression recommendation. But the commonality between Clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision and the proviso to Clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to Clause 3, because then it's worked itself out and the substantive part of Clause 3 and Article 370 becomes a permanent feature of the Constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to Clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under Clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Just see sub-article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause B of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, this is temporary within temporary. It is in respect of a situation where the Constitution now, a state has just come in, India is now become a republic, Constituent Assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government, it may give its concurrence and its consultation, but it should be very clear whether people want it. So they said, if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to Clause D continue to operate once the Constituent Assembly completed its task in 1957?
What has happened is that government also has said in their affidavit, and
or would that power be exhausted once the Constituent?
All provisions of the Constitution, They have applied all provisions of constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is fully in
But
operation.
then that is exactly.
We
But
are talking about
you're right,
repeal.
absolutely logically. But then why? How do we explain the fact that there were subsequent amendments to the constitution by the constituent orders?
What-
Because the provisos to clause D refer to state government. Clause 2 refers to the constituent assembly. And clause 2 says if the consent of the government was taken before the constituent assembly was formed, you have to place it before the constituent assembly.
But a wrong practice cannot result in
No, but
rewriting
sir,
a
we are talking
constitutional
of-
provision.
We're talking
We are
of a
moving-
practice over what? Over
But-
46 plus 18, 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed, then you continue with the practice. It's nobody's case.
That's completely out.
It's not- it's-
But otherwise, we
It's a
will have to
different
say,
argument.
But it is not
we will
petitioner's
have to
case
say
that
that-
no longer amendments of constitution can apply. That's not petitioner's case. Question is, what is it that was not supposed to have been agreed, a promise?
if the power under the proviso to clause 3 has exhausted itself, then equally the power under the two provisos to clause D has also exhausted itself.
For a moment,
In which case, how do we explain the exercise of that power for 64 years?
looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it.
Mr.
Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist.
Yeah.
The modality for exercise of the power under 370 bracket 3 is a different issue which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret
It is not.
clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power.
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, lordships are right, that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But, it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's the limited sense.
We'll move on.
Now just see.
Just 1 minute. Just
Please see, my lord, what your lordships are saying is answered in note 371B itself, what my lord Chief Justice is rightly putting. The power of Parliament to make laws for the state shall be limited to those matters in Union List, concurrent list, which in consultation with government of state are declared by President to correspond to matters to so and so, as the matters with respect to which Dominion may make law. So that's futuristic, may make law for the state. So any law that is made in future can be applied by the President under 371B. Then what such other matters in the state list as with concurrence of government of state resident may by order specify. So what this is futuristic exercise of power by the President from time to time. Likewise, Lord, in D, such other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modification as President may by order specify. So power of President is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the constitution are important in the opening of the article. Now just turn to Mr. Anger's broad statement. Please turn to plot PDF volume.
Away,
Why not?
whether under the second proviso,
Yes.
D, all the provisions of the constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government, under D, the entire provisions of the constitution could be made applicable to Jammu and Kashmir?
There could have been, except 370 can't be.
Except 370.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
Then what remains if everything under the constitution can be made applicable by exercising the powers under D?
No, it needs consultation and concurrence.
That's what if
Yes.
with the concurrence of
Yes.
the question that is being
No
put is
difficulty, it can be, undoubtedly. But the power of removing Article 370 is disappeared.
is a different power.
That's an independent power. And government union in its affidavit has stated that all provisions of articles of constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason. Except national security and some violence, they have not given any other reason also. So this has worked, it must continue to work. Now why it should continue to work, please see Professor Dr. Anger's broad statement. PDF volume 8, page 1175. The words again, the government of India had committed. Last para at page 1175 minus. Your lordships have got it.
again the government of India.
Yes. Again, the government, my lord Justice Call has got.
Just one.
Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistants. They're very talented.
The quality of assistance they give, especially matters of this nature,
Yes.
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
No, in fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because they assist, their assistance is amazing and their experience, but the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Again, the government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of constituent assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state. Now, kindly turn over and please come to Mulot page, the last clause, 8 pages later. The last clause refers to what? In fact, right from top, then we come to clause 2. 1178. Then we come to clause 2.
Mr. Dave, the portion you have read is part of the Constitutional Assembly debates relating to the Indian Constitution.
Yes. Part of the Constitutional Assembly debate on 17th of October 1949.
Correct.
Now, my lord, 1178, my lords may turn to.
1178.
Then we come to clause 2. You will remember, then we come to clause 2. You will remember that several of these clauses provide for the concurrence of government of Jammu and Kashmir state. Now, these relate particularly to matters which are not mentioned in instrument of accession. And it is one of our commitments to people of government of Kashmir that no such additions would be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination of Constituent Assembly of the state. Then about one paragraph later, the last clause refers to what may happen later on. Now see this, Lord. We have said Article 211A, which is 238, will not apply to J&K. But that cannot be a permanent feature of the constitution of the state, and hope it will not be so. So the provision is made that when the Constituent Assembly of the state has met and taken its decision both on constitution for the state and on the range of federal jurisdiction over the state, President may, on recommendation of the Constituent Assembly, issue an order that this Article 306A, which is 370, shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, recommendation of Constituent Assembly will be a condition precedent. That explains the whole of this article. Now see next para. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India. But the bogey is today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a Constituent Assembly in due course, which will go into matters I have referred. When it has come to a decision on the matters, it will make a recommendation to President who will either abrogate 3068 or direct that it shall apply with such modification exceptions or recommend. That, sir, is briefly description and effect of this article. I hope the House will carry it. And House carried it. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
CJI Rao.
CJI Rao. I was shocked to read because CJI Rao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordship knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharshi Aurobindo, who stayed in Baroda for many years, and some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s. So the man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford-Cambridge lines. So, and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that. Now, he therefore didn't want to. Now, just see, my learned friend wants me to read, at page 1177 perhaps, or 1178. Now it is not case. Which page? 1177, last para.
In fact, 1178, see that one para which says, now you will recall.
Yes. That in some of the clauses of this article, we have provided concurrence of government of state feel that in view of commitments already entered into between state and center, they cannot be regarded as final authorities for giving this concurrence, though they are prepared to give it in the interim period. But if they do give this concurrence, this clause provides that concurrence should be placed before Constituent Assembly when it meets, because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was still the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, my lord, that may perhaps.
What he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case,
3
really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
We see that
Yes.
on C and D at page 1177, clauses C and D refer. Your lordship see, clauses C and D refer to provisions of Constitution. My lords have it.
Yes.
Clauses C and D refer to the provisions of the Constitution other than matters listed in lists 1 and 3. These various provisions have been divided in certain categories. First, according to this draft, is Article 1 of the Constitution will automatically apply. As you know, it describes territory of India and includes amongst territories all states mentioned in Part 3. J&K is one of the states mentioned in Part 3. With regard to other provisions of the Constitution, these will apply to Jammu and Kashmir state with such exceptions and modification as may be decided on when President issues order to that effect. That order can be issued in regard to subjects mentioned in instrument of accession only after consultation of government of state. In other matters, concurrence of that government has to be taken. What your lordships read was in Part 2, because the government was an interim government. So, whether that government was rightly giving rightly giving advice or concurring, so they said, let people decide to that limited extent. Now, next para. Now, it is not the case, nor it is the intention of members of Kashmir government whom I took opportunity of consulting before this draft was finalized, it is not their intention that other provisions of constitution are not to apply. Their particular point of view is that these provisions should apply only in cases where they can suitably apply, when only subjects with modifications and exceptions as particular conditions of J&K state may require. I wish to say no more about particular point at the present. So that is how Lord he looked at it. That is how he defined. There is no other interpretation possible. This is the author. And one of the most respected, Lord, eminent citizens of this country. Lord, on 5th of August, President issues Lord, a proclamation. Then it is Lord, sent to Rajya Sabha. Rajya Sabha sends a recommendation without Lord, on the same day. Then Rajya Sabha approves Lord, reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. Lord, these Constituent Assembly debate took place over several years. These are the men and women, Lord, who are most brilliant that have ever been born in this country. We owe a permanent, Lord, gratitude to them. And if we were to interpret Constitution as today's governments tell us, we will be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of this country. And that pain they brought in various provisions. To recognize this. It's not even, the article is not just a letter. It's the feelings of people of Jammu and Kashmir.
What next, Mr.
Yes.
Davina?
Now, Lord, kindly come to, in this context, the two judgments which I respectfully submit are squarely supports the view that I have. Lord, kindly turn to PDF volume 1, isn't it? At page 8. Premnath called. It's 1950.
Volume 1 of the case.
On October 25, 1947.
Volume
7.
Which page?
So you can write volume 1, page 7. Case law compilation.
Para 10. Your Lordships may turn to para 10. Lordships have got it? On October 25, 1947, Maharaja signed an instrument of accession with India, which had then become an independent dominion. By first clause of instrument, the Maharaja declared that he had acceded to dominion of India with intent that Governor General of India, Dominion, Legislature and Federal Court and any other dominion authority established for purpose of dominion shall, by virtue of instrument of accession, subject always to the terms thereof and for the purposes only of dominion, exercise in relation to state of Jammu and Kashmir such functions as may be vested in them by or under Government of India Act and so on. So we may usefully refer to some of the other clauses of instrument. Then Lordships may omit all that. And please kindly, thus, last sentence of that para. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India. Now kindly turn to my lord. Lord, please turn to paragraph, there is one more argument. Page 287. Why haven't you written? PDF page 15. Para 26. No, where is para? Page 16. Para 26. There is one more. No, just before that. Bro, just before the paragraph 26, please see last sentence of para 25. We must therefore reject the argument that the execution of instrument of accession. Oh, para 26, last sentence. I'm sorry. Why are you confusing? I asked you to write this down and be carefully yesterday. Last part of para 26. We must therefore reject the argument that the execution of instrument of accession affected in any manner the legislative, executive and judicial powers in regard to government of state of which then vested in ruler of the state. So for all purposes, your Lordship's court recognized that not he was the state who wielded all the powers. And his instrument of accession didn't take away those powers. Although he became part of India. Now see, my lord, next paragraph. There is one more argument which has been heard before us on the question of Maharaja Hari Singh's powers. It said that Maharaja issued proclamation on March 5, 1948, replacing emergency administration by a popular interim government headed by Sheikh Abdullah, constituting council of ministers who were to function as cabinet and act on principle of joint responsibility. He virtually introduced a popular democratic government in state, surrendered his sovereign rights and became constitutional monarch. There is no substance in this argument. The proclamation merely shows under pressure of public opinion and as a result of difficult and delicate problem raised by tribal raid, Maharaja very wisely chose to entrust actual administration government to charge of popular cabinet. Then Lordships may omit all that and please kindly come to page. Lord, since Mr. Chatterjee has relied, page para 32. Page 18. Since Mr. Chatterjee has strongly relied on application of Article 370 of the Constitution to the state in support of his argument that Yuvraj has ceased to hold plenary legislative powers, it's necessary to examine provisions of this article and their effect. But these two judgments are a complete answer to what has happened. And these judgments bind your lordships. There is no reason to differ from this view. This article was intended to make temporary provisions with respect to state of Jammu and Kashmir, then so and so. Now, Lord, please see after the article, Lord, clause 1B of this article deals with legislative power of parliament to make laws for the state, and it prescribes limitations in that behalf. Under para 1, subclause B, clause 1, parliament has power to make laws for state in respect of matters in union list and concurrent list, which president in consultation with government of state declares to correspond to matters specified in instrument of accession. Whereas in regard to other matters in the state list, parliament may by under para 2 have power to legislate for the state after such other matters have been specified by his order by president with the concurrence of the government of the state. It is significant that para 1 refers to consultation with government of state while para 2 requires concurrence. Having thus provided for consultation with and concurrence of government of state, the explanation shows that government of state means in this what it means in this context. It means, according to appellant, not the Maharaja acting in his himself in his own discretion, but person who is recognized as Maharaja by president acting on advice of council of ministers for this. It is said on this explanation that appellant has placed great reliance. Subclauses C, D and 1 of article provide respectively provisions of article 1 and the present article shall apply in relation to the state, and that the other provisions of the constitution shall apply in relation to it, subject to exceptions and modifications specified by presidential orders. These provisions are likewise made subject to consultation with or concurrence of government of state respectively. Having provided for legislative power of parliament and for application of articles of constitution to the state, Article 372 prescribes that if concurrence of government of state required by relevant clauses has been given before Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly. For such decision it may take. This clause shows this, Lord, what your lordships are rightly, Lord, worried about. This clause shows that constitutional makers attach great importance to the final decision of the Constituent Assembly and continuance of exercise of powers conferred on the Parliament and President by very relevant temporary provisions of 371 is made conditional on the final approval by said Constituent Assembly in said matters. So what 371 continues with that. Once more it continues, then 373 becomes OTOs. Clause 3 authorizes President to declare public notifications that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by President only if Constituent Assembly of State makes recommendations in that behalf. Thus, proviso to clause 3 also emphasizes importance which was attached to final decision of Constituent Assembly in regard to relevant matters covered by 370. Now, my lord, please turn to next para on the same page on the said construction. Para 38. Para 38. But my lord, please omit first 10 lines or 5 lines. 5 lines. The constitution makers were obviously anxious. My lords have that? Para 38,
Yes.
fourth or fifth line. The constitutional makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself, not by Indian Parliament. State itself. And that is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. It would not be permissible or legitimate to hold that by implication this article sought to impose limitations on plenary legislative powers of Maharaja. These powers had been recognized, specifically provided by the Constitution Act of the state. It was not and could not have been within contemplation of competence of constitutional makers to impinge even indirectly on the said powers. So from Maharaja they got transferred to Constituent Assembly, those powers. So they say that you can't impinge on those powers. It would be recalled that by instrument of accession, these powers have been expressly recognized and preserved, and neither subsequent proclamation by Yuvraj Karan Singh adopting as far as applicable the proposed constitution, nor constitutional order subsequently issued by President purported to impose any limitation on said legislative powers of the ruler. Please see this. These decisions I have completely answered long back. What form of government the state should adopt was a matter which had to be and naturally left to be decided by Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf. Now see these words. Until the Constitution Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by instrument of accession. It would therefore be unreasonable to assume that application of 370 could have affected or was intended to affect plenary powers of Maharaja in matter of governance. In our opinion, appellant's contention based on this article is therefore rejected. Now, Lord, please turn to this para because this is a little important. It is difficult to see how this article purports. Para 40. Para 40, but not after 12 lines. The word starting with the constitutional position. 10, 12 lines. How many? PDF 21.
Altogether issue whether the Yuvraj would have really issued the
Down to Sampath Prakash now.
Sampath Prakash.
Same volume. It starts at page 27 at 30. 27 at 30. On the earlier page at 29, but at 30, please see the answer. Learned counsel urged, in this background, Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed.
You are reading paragraph?
Learned counsel, okay.
Page 30, para 4. Para 4.
Just the paragraph above para 5.
Yes. Learned counsel urged that this background Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed and the will of the people of J&K had been expressed, and thereafter this article must be held to have become ineffective, so that modifications made by President in exercise of powers under this article subsequent to enforcement of Constitution of state would be without any authority of law. Now please see the answer to that. Next para. We are not impressed by either of these two arguments advanced by Mr. Ramamurthy. So far as historical background is concerned, Attorney General appearing on behalf of government also relied to urge that provisions of Article 370 should be held to be continuing in force. Please see that note. Mr. Daftari. Should be held to be continuing in force because situation that existed when this article was incorporated had not materially altered, and purpose of introducing this article was to empower President to exercise discretion in applying Indian Constitution. There is considerable force in this submission. Legislative history of this article cannot in these circumstances be of any assistance, that this article became ineffective after Constituent Assembly of the state had framed the Constitution.
Yeah.
It is again.
Completely against you, Mr. Dave.
Please see that. There are, however, much stronger reasons for holding previous.
Even para 5, it says should be held to be continuing in force.
Yes.
And then 6,
7, in fact, 6 and 7.
6 says that the second submission based on 2 of Article 370 does not find support even from the language of that clause, which only refers to the concurrence given by the government of the state before the Constituent Assembly
Just a
Assembly,
second.
and makes
The
no
second
mention at all of the completion of the work of the
Does
Constituent
not
Assembly.
find support even from language of that clause, which only refers to concurrence given by government before the Constituent Assembly was. That's what I'm submitting. No, that's a very limited. It's a temporary provision within a temporary provision.
But this seems to give the, seems to hold that the article in its entirety would continue to govern even after the Constituent Assembly had completed its task.
No, not as a whole.
Read 7.
Just the para 7.
Let me read it now. Your Lordship may allow me to complete.
Yeah.
There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after Constituent Assembly of State had passed Constitution. The most important provision in this connection is contained in clause 3 of article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as President may by public notification provided recommendation of Constituent Assembly of State referred to in clause 2 shall be necessary before President issues. This clause clearly envisages that article will continue to be operative and can cease to be operative only if, on the recommendation of Constituent Assembly of the state, President makes a notification direction to that effect. In fact, no such recommendation was made by Constituent Assembly of the state, nor was order made by President declaring article shall cease to be operative. On the contrary, that's important. It appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in the article was notified by the President by Ministerial Law Order dated 15 November 52 and laid down that from 17th November, article was to be operative with substitution of new explanation for old explanation. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article by making a recommendation it should be operative with modification only. Lord, it can't be, you can't now resort to 373 to repeal it. Constituent Assembly has accepted, it's a one-time exercise.
Not repealed.
President accepted, acted upon it.
It is not repealed, Mr.
No, it becomes inoperative.
So from time to time, this is what I said earlier, time to time COs have been issued.
No, we are not on 371. I am on 370 sub-article 3.
Even the present exercise, other argument being open, it is not removed. It has applied the other provision. As it exists in the statute of the Constitution.
No, Lord, they have repealed it. They have deleted it. They have exercised 373 to delete it.
All
The word
provisions,
is, I'll just tell you.
now as it stands is, all provisions of this Constitution amended from time to time still will apply.
Yes, but they have abrogated 370 and applied all the provisions of the Constitution. Both they have done. That part was not permissible. Now see furthermore.
So Dave,
Hmm.
we can just go a little earlier. Paragraph 4.
Yes,
First argument and the second argument that will clarify the situation.
the,
It's at page number 29, 28 rather. The first argument
Yeah.
was that the
first
article,
argument was that this article contained temporary provision which ceased to be effective after Constituent Assembly convened for purpose of framing Constitution of J&K had completed its task by framing Constitution. Reliance was placed on historical background in 370 included so. Then Lordships may omit. The answer is what
and then it goes also, as you have done,
Now the new one.
and in this background, then it's stated that background Article 370 could have been intended to remain effective till the constitution of the state was framed and the people of Jammu and Kashmir had been expressed, and thereafter must be ceased to have become ineffective so that modifications made by the president and
without authority. Now see the answer. I'm grateful to your Lordships. Your Lordship said no. But we are not on that. It's not our contention that 371 doesn't apply or president can't exercise powers under 370 as sub-article 1. That's not recorded in at page PDF page 31 para 7. That's the answer. That it was not left to the Constituent Assembly, otherwise it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation or the president will make a recommendation or parliament will resolve. Here what they have done is that parliament resolved. That's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373 abrogating it. It's an extraordinary I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power.
Reading right.
Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But Lord, it can't be because that has come to an end. Lord, speaking for Federal Court, Chief Justice Kanya said this, Lord, in 1949 FCR. Lord, Jatindranath Gupta versus Bihar, Lordships are aware of that judgment. As a general rule, and unless it contains some special provision to the contrary, after a temporary statute has expired, no proceedings can be taken upon it as it ceases to have any further effect. 373 is that. 1949 FCR 595. It's at volume 30, plot page 18. I'm not going to trouble reading it. But this is a state, and this has been recognized subsequently. Even General Clauses Act doesn't apply. Your Lordship said to temporary statutes. And Article 367 expressly begins with a non-obstant clause subject to the contrary. Article 367 begins with a non-obstant clause, says subject to the contrary, unless context otherwise requires. Now, Lord, 370, therefore, context is completely different.
Does apply. Section 21 will apply, that what is said.
I am looking to the statute and making submission on, because federal court judgment was not granted. I'm sure you will get opportunity.
No, this judgment says that the General Clauses Act will apply. Actually.
Yes, I have seen that, Lord. I have seen that. I have marked that portion also. But Lord, my respectful submission is that here, because of the context of 373, I respectfully submit that in respect of sub-article 3, there is no question that it should apply. Now, Lord, one judgment that I would like to place before your Lordship for consideration is, Lord, so Lord, this is my second my argument that Lord 370, Lord, sub-article 3 stood exhausted, and therefore President Lord neither could exercise powers nor could Parliament recommend to the President to exercise that power. Now, Lord, just to look at the counter affidavit which has been filed on behalf of Union of India. Lord, common counter on all, it says, Lord, it's a counter which is for all, a comprehensive counter, they call it. PDF file, common counter.
This will be in the paper book, right?
Yes.
501.7.
Oh, 501.7.
Thank you, Mr. Gordon.
501.7.
Suryakant has. Mr. Courtmaster, kindly.
Page PDF?
2990.
2990.
Which is the internal page. Yeah, you're on the right side. So the way?
Lord, the Lordships may kindly turn to page 13. Do your Lordships have page 13?
It will be 3104.
Sub-para 7. 7. 7 or 8? What is it? 8. As has been explained in greater detail.
Just 1 second.
Para
5.
16, Mr. Mehta.
3005.
At page 13.
Para 7.
Page 3005.
30 PDF
That's
3
the can you turn to para 7?
PDF 3005.
As has been explained in greater detail in later paragraphs of this affidavit, it was observed over years. Existing regime under Article 370 and exemptions modifications carried out to the provisions of Constitution of India by presidential orders issued under 371D were impeding rather than enabling, facilitating full integration of erstwhile state of Jammu and Kashmir with rest of the country, which was neither in national interest nor in interest of state of Jammu and Kashmir. How impeding? Somebody makes a statement from Home Ministry, now giving no detail as to how it has impeded. Law and order problem certainly exists, but it is not because of applicability or otherwise of the Constitution. Now, please turn over, Lord, kindly turn to paragraph, straight away to paragraph, Lord, page 18. Page 18. Part of para 8, no? Roman 5. Lordship said that? Page 20 perhaps, PDF page 20.
Mr. Dave, are you inviting the court to review the wisdom of the decision of the government on the abrogation of 370? So you're saying that judicial review should reassess the basis of the government's decision that it was not in the national interest to continue with Article 370.
As Chief Justice Chandrachud said in A.K. Roy, that not this theory that was developed in United States Supreme Court, that political decisions courts shouldn't go into. That is now, that was given and in Podial, your lordships expressly rejected that argument.
But judicial review would be confined to a constitutional violation. Constitutional violation, certainly it's amenable to judicial review.
Lord, I would respectfully submit that even subject.
There's no doubt that if there's a constitutional violation, this court has a jurisdiction to review. Of course, that's undoubted.
Let me put it this way. President is undoubtedly exercising powers under 370, purportedly. In Samsher Singh, your lordships have said that president can only exercise presidential power in constitutional sense. No other sense, not personal.
But the wisdom underlying the decision to abrogate.
There is no question of wisdom. President can only look at 370. President has to be advised by his advisors that 373 does not exist today.
We are back therefore to the constitutional argument. Constitutional argument, of course, judicial review is available, and we are addressing ourselves to that. There's no doubt about it.
Your lordships are right.
Fraud on the Constitution.
I am on fraud on Constitution that president is today exercising a power without any material whatsoever, without any justification whatsoever, and to wish it away by simply saying that it was impeding. Well, surely this court is not going to accept that kind of a very cavalier affidavit on part of Union of India. Yes. To say.
370 would.
Argument was this, that these are political questions, don't go into it. Your lordship said nothing doing, we will go into them. And now after Bomai, your lordships have expanded the horizon. Your lordships have gone to an extent. Now just see two more things in this affidavit. Kindly turn to paragraph 15. It's a bundle of contradiction, their affidavit.
Paragraph 15?
Yes.
What PDF page will that be?
PDF 25. Oh, thank you, Mr. Gopal.
3015.
I state and submit that Constituent Assembly of erstwhile State of Jammu and Kashmir did not in any manner deviate. Please see that word. Did not in any manner deviate from provisions of Constitution of India, which would be applicable to erstwhile State of Jammu and Kashmir. Constitution of J&K adopted by this Constituent Assembly included Section 3, which unequivocally stated, State of Jammu and Kashmir is and shall be an integral part of Union of India. Additionally, Section 5 stated, executive and legislative power of state extends to all matters, except those with respect to which Parliament has power to make laws for state under provisions of the Constitution of India. There can be no doubt
By the way, do we really need to labor on the counter? We have to interpret the constitutional provision as it stands. How is this relevant?
Your lordships are right. I am submitting that there are no reasons available in presidential exercise, nor are they given in counter. It's bereft of many reasons, the whole entire exercise. That's my respectful sir.
Yes.
Now see last sentence. There can be no doubt, therefore, Jammu and Kashmir became integral part of India, and Constituent Assembly, an elected body, had also given its imprimatur to the provisions of Constitution of India. Now, Lord, please see in this regard, Lord, two decisions. Lord, kindly turn to the judgment of Lord. Lord, not on fraud. Just see Lord, one paragraph of this judgment.
Now, what are you referring?
Lord, this is the Constitution bench judgment in Mudaliar on Lord, fraud on the Constitution. Just see Lord this interpretation, and then I'll take to the next.
Where will we get it, Mr. Bharat?
Volume 28, case law volume 28, page 8, and relevant part at 15. 8 at 15.
Volume 28, case law compilation.
This leads. Oh, PDF page 19, I'm sorry.
Page 9.
This leads us to the consideration.
Mudaliar is at internal page 7, right?
16.
Just see at page 19. Open PDF, then there is
8 at what para?
para
16.
16. This leads us to the consideration of the question of scope of doctrine of fraud on power. In Gajpati Narayan, Mukherjee, Justice Mukherjee, as he then was, explained the doctrine. It may be made clear that outset doctrine of colorable legislation does not involve any question of bona fides or mala fides. The whole doctrine resolves into a question of competency of a particular legislation. If legislature is competent to pass law, motives which impelled it are irrelevant. On the other hand, if legislature lacks competency, question of motive does not arise. Whether a statute is constitutional or not is thus always a question of power. Learned Judge describes how legislature may transgress the limits. Now, this is important. Such transgression may be patent, manifest, or direct, but it may also be disguised, covert, or indirect. And it is to this later class of cases that expression colorable legislation has been applied in certain judicial pronouncements. Now, Lord, in DC Vadva, your lordships go further, and that is at page. Parliamentary recommendation, Lord, in my respectful submission, suffers from complete colorable exercise of parliamentary powers. It was neither exercising constituent power under 368 nor any legislative power. Resolutions are passed by Parliament on many issues, sometimes not even to honor some individuals or to say some other things or to recognize great events in the country. So Parliament here passes resolution and says, Mr. President, you kindly do this. That, not in my respectful submission, is a pure act outside parliamentary broad powers. And they did it only because the assembly was dissolved, purporting to act as assembly of JNK. That we are now, since assembly is dissolved, therefore president has the powers and parliament therefore has powers under 356. Page PDF. What? Volume 19, my lord. Page 118. Just one para. That one para. Lord, para 7, PDF page 131.
Which judgment is this?
Lord, this is DC Vadwa
1 second. Page, PDF page?
of volume 19, 118 at 131.
No, that's some other judgment.
The state of
is-
Tamil Nadu.
That's state of Tamil Nadu versus Padmavati Ammal.
Volume 19,
19.
PDF 131, I think 131,
One.
volume 19. You are referring to DC Vadwa?
Yes, my lord.
Yes, difference.
So we have some other judgment.
No,
Padmavati Ammal.
Yes, Padmavati.
19 page, what is the PDF page number?
Oh, yes, it's 118 actually. It's immediately after that. It's 118.
9859.
Page 118 at 131.
131, para 7. Where does it begin?
State of Tamil Nadu.
हाँ नहीं उसके बाद में
No trouble, your lordships, reading that. The emergency power of the governor was not in the context of ordinances, but just above where Justice Mukherjee's dictum in Gajpati Narayan is cited, just above that,
At-
4 lines above that,
at page 133. Huh?
133. It is settled law. No, this is what I place for your lordship's kind consideration. It is settled law that a constitutional authority cannot do indirectly what is not permitted to directly. If there is a constitutional provision inhibiting the constitutional authority from doing an act, such provision cannot be
Yeah.
allowed to be defeated by adoption of any subterfuge. That would clearly be a fraud on the constitutional provision. This is precisely what was pointed out by Justice Mukherjee. And that's my respectful submission that Lord and Lord Mudaliar is also considered. Now, Lord, last judgment that I placed for your lordships is the UP Assembly case, volume 30,
This was paragraph
PDF page 73.
33, page 1. Just
Here, volume 30, PDF 73 at 92.
Volume?
38. Volume 30, my lord. Volume 30. So, Lord, this is the special reference.
PDF?
PDF 30. Sorry, PDF 73. Volume 30, PDF 73 at 92, para 38.
What's the name of the case?
Yeah.
What is that? Any powers, privileges, and immunities of state. UP case.
What page are you referring to?
So Lord, at para 38, 92.
92.
Page 92, para 38.
In dealing with this question.
Yes, ma'am. Grateful. All your lordships have that? My Lord Justice Khanna?
Just give me a minute.
Yes.
Paragraph number?
38.
38. Okay. Yes.
In dealing with this question, it's necessary to bear in mind one fundamental feature of federal constitution. In England, parliament is sovereign, and in words of Dicey, the three distinguishing features of the principle of parliamentary sovereignty are that parliament has right to make or unmake any law whatever, that no person or body is recognized by law of England is having a right to override or set aside legislation of parliament, and that right or power of parliament extends to every part of Queen's dominion. On the other hand, essential characteristic of federalism is distribution of limited executive, legislative and judicial authority among bodies which are coordinate with independent of each other. Supremacy of constitution is a fundamental to existence of a federal state in order to prevent either the legislature of federal unit or those of the member states from destroying or impairing that delicate balance of power. That's precisely what has happened, destroyed the delicate balance of power, which satisfies the particular requirements of states which are desirous of union, but not prepared to merge their individuality in unity. Lord, you can't rewrite history. And a constitutional history can certainly be never rewritten. That's why it's durability. This supremacy of constitution is protected by the authority of an independent judicial body. Your lordships, independent judicial body to act as interpreter of a scheme of distribution of powers, nor is any change possible in the constitution by the ordinary process of federal or state legislation. Ordinary process, 370, President issues, Parliament pass resolution.
Yes, Mr. Ravi.
Thus, the dominant characteristic of British Constitution cannot be claimed by a federal constitution like ours. Then what next paragraph? Our legislature have undoubtedly plenary powers, but these powers are controlled by basic concepts of the written constitution itself and can be exercised within legislative fields allotted to their jurisdiction by 3 lists under the 7th schedule. But beyond the list, legislature cannot travel. They can no doubt exercise their plenary legislative authority and discharge their legislative functions by virtue of powers conferred on them by relevant provisions of the Constitution. But the basis of power is Constitution itself.
Yes, Mr. Ravi, we read that. Thank you. Which is the next judgment, Mr. Ravi?
Lord, one sentence, Lord, in
Yes.
paragraph 40, last sentence, PDF page 93. Therefore, there can be no doubt that the sovereignty which can be claimed by Parliament in England cannot be claimed by any legislature in India in the literal absolute sense.
Yes.
So, Lord, whichever way one looks at it, Lord, your lordships may look at the UP Assembly case, or your lordships may look at Samsher Singh's case. If not, the exercise of power by the Constitution or by the Parliament has to be done under the Constitution itself and in the constitutional sense, then in my respectful submission, Lord, constitutional sense or constitutional provisions prohibited both the President and Parliament from Lord, touching Article 370, sub-Article 3 in any manner to abrogate it. There is no power to abrogate Lord 370 under 373 because Lord, as I respectfully submitted, that Lord, it has lived its purpose, its object, and therefore it no longer is Lord available for exercise. In any case, the exercise Lord suffers from a fraud on the Constitution because Lord, it has been done completely contrary to constitutional provision. And Lord, the principle of federalism, principle of democracy, which Lord Bombay has so beautifully Lord ascribed. Because ultimately, that's why Lord, constitutional framers were very conscious. Let the people of Jammu and Kashmir decide how they want their relationship. They decided for all times to come. It was not Lord, it was not a temporary exercise by Constituent Assembly. That's why I said, it would be travesty of justice that Constituent or Legislative Assembly of Jammu and Kashmir were now to be given authority to say that no, the Constitution of India will not apply to us. That power also for them stands exhausted. So, those are my respectful submissions. Therefore, I respectfully submit. There is one aspect which, yes, I must tell you. In my written submissions, I have quoted from the 2019 manifesto of the Bharatiya Janata Party. In that, they expressly said that we will work towards abrogating Article 370. But in my respectful submission, this court has already said in 2013 judgment that these manifestos can't be contrary to constitutional scheme. One, and directed EC to issue guidelines. 2015 EC issued guidelines and told all political parties that your manifestos must be within the constitutional scheme and spirit. Now, today, because you have majority in parliament, you have done not for any purpose. So, his argument of impeding, etc., is not relevant at all. It doesn't exist. The only reason you have done it because you told people of India to vote for you because I will go and abrogate Article 370. That shows that the power has been exercised for colorable considerations. The actual exercise is fraught with clearly, I would say, irrelevant considerations which cannot apply to constitutional exercise. The president is not a rubber stamp. He had to see this. Yes, you have the majority in parliament, but majority doesn't speak. It's not a constituent power. You didn't want to go, therefore, to the majority of both houses of parliament. You didn't want to do that. You didn't want to go to legislature because you are now taking away out of 5 Lok Sabha members and 4 Rajya Sabha members. Once you divide territory, those members, that representation is gone. If the representation is gone by virtue of Article 368(1), you are supposed to go to many state legislatures and take their approval because they are also concerned. 368 is very beautifully worded. There are so many safeguards in it. So, those are my respectful submissions.
Thanks, Mr. Dave.
Deeply obliged.
Thank you, Mr. Dave. Who will argue now, Mr. Thank you, Mr. Mr. Dwivedi will argue now.
It's been a privilege. Grateful.
Oh, Mr. Nafri will argue.
There are few aspects which I would like to highlight. The burden of my song is very simple. Beneath the apparent constitutionality lies the patent illegality. Now, how do I demonstrate that? So in the first place, it has been argued extensively that the effect of Constitutional Order 272 is amendment of Article 370, Clause 3. This has been extensively argued. This has been done via the route of Article 367. Now, 371D empowers the President to apply the provisions of the Constitution to Jammu and Kashmir. Now, with such exceptions and modifications, these are the words used. Now, the question that arises is whether this power to modify, whether there are any implied limitations on this power. This is the first my submission. Now, take for example, while applying the Indian Constitution to Jammu and Kashmir, the modification says Article 21 will not apply, Article 14 will not apply. Will it or will it not trouble your conscience? So therefore, my first submission is that there are implied limitations on this power to modify. And what are those limitations? We'll examine. So what have they done? Instead of Constituent Assembly, it is replaced by Legislative Assembly. Whether this is permissible, whether it falls within the ambit of the term modification, or it goes far beyond that. So if your lordships look at the Constitutional Order 272, it adds the word in the Constitution of India as it originally stands. There is no such definition. So it's an addition. I am prepared to assume for the time being that modification can take in its within its compass even addition. But the question is that you are replacing a fundamental concept, the core concept of Constituent Assembly by another legal concept known as Legislative Assembly. The fundamental difference between these two concepts is well known. Now, therefore, your lordship will see that a Legislative Assembly is a product, is a creature of Constituent Assembly. Now, therefore, in my respectful submission, this exercise is not permissible. Now, take another example, which is to be found in the judgment of Justice Khanna in Keshwananda Bharati case. I will invite your lordship's attention. His lordship had raised the question that suppose the parliament in exercise of its constituent power says that the existing parliament will continue for 50 years. Will it or will it not be a mockery? Kindly see that paragraph in the judgment of Justice Khanna. Your lordship will get it in PDF page yeah, I'll just. So the PDF page is 7426.
Which volume?
Is the volume? Volume 15. The PDF page is 7426. No, sorry, I stand corrected. 527. 571.
Volume 15.
571.
Volume 15.
And the paragraph is 1423. Kindly see what the lordship says.
It's at page?
Page 1423. Sorry, paragraph 1423. PDF page
571.
571. I get confused between PDF page and the
Paragraph
page that I have. Paragraph 1423, sir. So this is how that para runs. Apart from the fact that the best guarantee against the abuse of power of amendment of part 3 of the Constitution. There is another aspect of the matter. Even if part 3 may be left intact, a mockery of the entire parliamentary system can be made by amending Articles 85 and 172, which are not in part 3, and according to which the life of the Lok Sabha and the Vidhan Sabha of the states, unless sooner dissolved, would be 5 years, and by providing that the life of existing Lok Sabha and Vidhan Sabha shall be 50 years. This would be a flagrant abuse of the power of amendment, and I refuse to believe, etc. Now, this is precisely the situation. The second judgment on which, of course, this is the only observation made in the judgment. I am not saying that this constitutes the ratio, but it is something which your lordship will bear in mind. Now, kindly see the second judgment on which I place reliance. That is Indri Delilaw's case.
Indri?
Indri Delilaw's case, and It is there in volume 25, and the PDF page starts at page 524. And I invite your Lordship's attention to page 546. So in that, on that page,
What's the
section
PDF?
7,
Which is the PDF number?
546.
PDF number.
So on that page, your Lordship will find section 7 has been quoted.
Para?
Could you please repeat
Para
the
41 of the judgment.
page?
546.
524 I have, 546 now.
And para 41, my Lord,
Which is the volume, sorry?
volume
25.
25. Volume 25. So kindly see where their Lordships have quoted the section in para 41. The provincial government may, by notification in the official gazette, extend with such restrictions and modifications
I will
as
now
it
read the
thinks
3
fit
points.
to the province of Delhi
Section 7.
or any part thereof, any enactment which is in force in any part of the British India at the date of such notification. Now we are concerned with the word modification. Now this has been construed by, this is a 7-bench judgment, and if your Lordships come to first Chief Justice Kanial's observations on this, your Lordship will come to page 726 of the PDF. So para 354, the power to modify an act in its extension by the order of the subordinate authority has also come in considerable discussion. Originally, when the power was conferred on the subordinate authority to apply existing legislation to specified area, it was given only to apply the whole or a portion thereof. That power was further expanded by giving a power to restrict its application also. In the next stage, however, was given to modify so as to adapt the same to the local conditions. It is obvious that till this stage, the clear intention was that the delegate on whom the power was conferred was only left with the discretion to apply what was considered suitable as a whole or in part, and to make adaptations which became necessary because of the local conditions. Nothing more. Only in the recent years, in some acts, power of modification is given without any words or limitations on that power. The learned Attorney General contended that the word modify, according to the Oxford Dictionary, means to limit, restrain, to assuage, to make less severe, rigorous, or decisive, to tone down. It is also given the meaning to make partial changes, to alter without radical transformation. So this is important. He therefore contended that if the donee of the power exceeded the limits of the power of modification beyond the sense that it could be exceeding the limits of the power, and to that extent the exercise of the power may be declared invalid. He claimed that no longer a power under the term modification. On the other hand, so and so words expresses the word modify has been defined as meaning vary, extend, enlarge, limit, or restrict. It has been held that the modification implies an alteration. It may narrow or enlarge the provisions of the former act. It has also been pointed out that under the powers conferred by the Delhi Laws Act, the central government has extended the application of the Bombay Debtors Relief Act to Delhi. The Bombay Act limits its application to poor agriculturalists whose agricultural income is less than so and so. Under the power of modification conferred by the Delhi Laws Act, the central government has removed this limit on the income with the result that the principles, policy and machinery to give relief to the poor peasants or agriculturists with an income of less than 500 is made applicable to Delhi to big landlords, even with an income of 20 lakhs. This shows how the word modification is understood and applied by the central government and acquiesced in
Yes,
by the
Mr.
Indian
Mafia, we've
race.
seen that, yes.
Now, this is a classic example, and this is precisely what has happened. There is a qualitative difference, conceptual difference between the Constituent Assembly and the Legislative Assembly. So the same thing has been repeated. I'll just give to your Lordship the paragraph numbers. That is Justice Mahajan, paragraph 414. The PDF page is 760. Justice Vivian Bose, para 316, PDF page 698. Justice Fazal Ali, para 46, PDF page 553, and Justice Mukherjee, paragraph 155, PDF page 613. So your lordships have laid down that there are implied limitations on the power to modify. And the one classic example I gave was, suppose they say no Article 21 in Jammu Kashmir. Whether such modification can be sustained. Now this judgment was cited in Puranlal Lakhanpal. And I want to show to your lordship what the judgment says. So kindly come to the judgment in Puranlal's case. Your lordship will find it in volume 1, PDF page 2426. Judgment was delivered by Lordship Justice Vanchu. Fortunately, there is only one judgment, so that we understand the ratio.
Volume 1,
Yeah.
page
Otherwise,
number,
we are grappling to find out what is the ratio of case 1 and case.
page number,
The page is PDF page is 25. The judgment begins at page 24, and it is in volume 1. Now, kindly see, my lord, Article 81 was modified. Now, this is the modification. Article 81 shall apply to subject to the modification that the representatives of the state in the House of the People shall be appointed by the President on the recommendations of the legislature of the state. So instead of a direct election, the indirect election, that the legislature of the state shall recommend the names of persons who are to be appointed as members of the parliament to represent J&K. Now, this was impugned on the ground that the modification crosses the legitimate limits. Now, in paragraph 3, your lordships have said on page 25, PDF page 25, this is what the paragraph 3 says. And according to me, this is the ratio. Before we consider what the word modification means in the context of Article 371, let us see what the President has actually done in the matter of modification of Article 81. The modification prescribes that the 6 seats in the House of the People from state of Jammu and Kashmir would be filled by nomination by the President on the recommendation of the legislature of the state. Now, in form, the seats will be filled by nomination by the President, but in the reality, what the modification provides is indirect election in place of direct election to these seats in the House of the People, the modification lays down that the president will nominate members to these 6 seats on the recommendation of the legislature of the state. The president must therefore nominate only those who have been recommended by the legislature of the state, which is elected on adult suffrage. Now, the only way the legislature can make a recommendation for this purpose is by voting. Therefore, in effect, the modification made by the president is that the 6 seats to the House of the People from the state of Jammu and Kashmir will be filled by indirect election and not by direct election. The element of election still remains in the matter of filling those seats, though it has been made indirect. In these circumstances, it may not be possible to say that there has been a radical alteration in the article. Now, this proposition itself may be debatable, but the point is that in paragraph 3, your lordships have said that there is no radical alteration. Now, in paragraph 4, then their lordships say, but assuming that the introduction of the indirect election by this nominee is a radical alteration, and that is permissible. Now, how do I deal with this para 4? So, my submission is that 2 issues arose before the court. First, whether it's a radical alteration, and second, assuming it's a radical alteration, whether it is within the ambit of 371D. Now, the second issue did arise for the court's consideration, but in my respectful submission, the determination of this issue is an arbiter and not ratio. What is the difference between a ratio and an arbiter? A ratio is that proposition which the court has to decide, has to lay down, so that the case is finally disposed of.
So according to you, once the court had held that this was not a radical modification,
The
question as to whether a radical modification is permissible really didn't arise. That was
an
moved.
arbiter.
Got it.
And for this purpose, I rely upon a judgment of the Bombay High Court. Unfortunately, it was not there in the, but we have circulated, I'm told. And I just want to show to your lordship how Chief Justice Chagla deals with this concept of ratio and arbiter.
On the second aspect, what does the court, just let's see that.
The second,
The arbiter, let's see the arbiter.
the paragraph 4 is an arbiter according to me.
Let's read that.
Yes, all right, I'll read that. But even assuming that the introduction of the indirect election by the
I will return
is a radical alteration.
I will return after lunch.
Modification is justified by the word modification as used in Article 371. We are here dealing with the provisions of a constitution which cannot be interpreted in any narrow or pedantic sense. So I pause here for a minute. Their lordships are now comparing Delhi law's case and this provision in the constitution. Now my humble submission is that as far as Delhi laws is concerned, it's ordinary statute. Therefore, there can be a more flexibility.
Yes.
But when you are dealing with a constitutional document, the limitations should be on a higher scale. This point is missed out. Kindly see further. The question that came for consideration in the Delhi law case was with respect to the power delegation.
Yes, Mr. Nafta, I think we got your point that, you have to have some implied limitations. And therefore, these observations in para 4 are of a very broad amplitude.
Your lordship sees the para 4.
We'll have to hear the other side. You made your point. We'll hear the other side of this.
Completely wipe out.
All right. What is the next point, Mr. Nafta?
So my next point is, which I will indicate at the end, because I have to deal with Article 3 and 4 as briefly as possible. But my next point is, what happens to the constitution of Jammu Kashmir? That's a thorny question. So if I recapitulate the facts which have been extensively set out in the Brennan Kaur's case and which has been cited before your lordship.
So, what is the submission on this
The
aspect?
submission which I want to make is this. So it traces out, the judgment traces out how the sovereignty came to be vested in the Yuvraj. Right from 1925 to 1951 or 49. And thereafter, two important developments. Yuvraj accepts the Constitution of India. But that is in the light of Clause 8 of the Treaty of Accession. Clause 8 recognizes that barring a few items, the sovereignty of the Maharaja remains. Now this sovereignty, which is recognized by the Accession Treaty, where and when does it evaporate? That's the question. Because as a result of this constitutional order and the Reorganization Act, the result is the Jammu and Kashmir Constitution comes to an end. Now let me elaborate this point, sir.
But that's postulated. And over the passage of time, even of time, what was left, as pointed out by Dr. Naval, was only limited, very, very limited, small.
Several provisions came to be applied, no difficulty. But the core of the J&K Constitution has remained intact till date, which I will indicate to your lordship. So therefore your lordship will see that it is in 1951 that Yuvraj convened the Constituent Assembly to frame the Constitution. What is the authority by which he could do so? His authority to convene the Constituent Assembly has not been questioned anywhere. So therefore, J&K Constitution is a constitutional document. That's the only conclusion possible. Now my submission is going to be that no matter how widely you interpret the power under 371D, the core of the J&K Constitution must remain. And what is that core? So kindly come to J&K Constitution. That is in volume 2. So in the first place, the state.
So can you itemize the core? I mean, can you just sort of summarize what would be the core?
The core I am indicating, that is part 5 and part 6 of the J&K Constitution.
That is the executive.
That is part 5 is executive and part 6 is the legislature.
Additional document, volume 2. Additional document.
Sir, when the constitution was ushered in,
Which is a one more provision. Part 5 is the
is the executive, governor, council of
Part 6 is
ministers,
the legislature, and what else?
and the legislature.
These two.
And kindly see,
said one more.
section 3 and 4. Sections 3
Document volume.
and 5. That is part 2.
Yes.
Now the state of Jammu and Kashmir has its origin also in this, its continuation. It originally existed. There is a long history which has been set out in Remnath Kaur's case, right up to independence, 1947 Act, Treaty of Accession, etc. Now kindly see the territory, section 4. Constitution.
पूरा वही document है.
The territory, the PDF page is 18. The territory of the state shall comprise all territories which on the 15th day of August 1947 were under the sovereignty and suzerainty of the ruler of the state. Now this is the territorial integrity of the state. Now there is no provision in the Constitution of India by which the J&K Constitution can be abrogated. There is no express provision. The only question is whether through the route of 371D this can be achieved. Now this depends upon the question, because Article 370 itself recognizes the Constituent Assembly. And the concept of Constituent Assembly is that it's a sovereign body. Now there can be a constitution within a constitution. That is something which your lordships have recognized. I just indicate to your lordship. That your lordship will find in the judgment of Keshavananda Bharati. Para 2072. I just indicate PDF page 79091.
Volume.
Volume 15, sir.
We'll look at it. Page, just give us the page
790.
which says that there can be a constitution within a constitution.
Constitution.
Okay.
That's what
Whose judgment is that?
Justice Chandrachud. Now, therefore, your lordship see the existence of level portion.
You should write that.
Yes.
Thus, the true ground of division by virtue of which the nature of the constitution is whether it is flexible or rigid. That depends upon whether the process of constitutional lawmaking is or is not identical with the process of ordinary lawmaking. A typical instance of flexible constitution is that of the United Kingdom. The constitution of the former kingdom of Italy was also flexible, so flexible indeed that Mussolini was able to profoundly violate the spirit of the constitution without having to denounce it. The constitution of the United States is rigid as it cannot be amended without the special machinery being set in motion for this purpose. In short, we may say that the constitution which cannot be bent without being broken is a rigid constitution. The Indian constitution, considered as a whole, is a controlled or a rigid constitution because broadly none of the articles of the constitution can be amended otherwise than by special procedure prescribed by Article 368. Certain provisions, therefore, like Article 4, read with Articles 2 and 3, Article 169, Para 7 of the 5th Schedule, and Para 21 of the 6th Schedule confer power to amend the provisions of the Constitution by ordinary lawmaking process. But these amendments are expressly accepted by the respective provisions from the purview of Article 368. Schedules 5 and 6 of the Constitution are in fact constitution within a constitution. So therefore, the existence of J&K Constitution is recognized by the Constitution of India. How do I show that? Kindly turn to Article 370.
That you need not labor because according to you, the
It refers to.
Constituent Assembly itself.
Now the question therefore is that if the Jammu and Kashmir Constituent Assembly was convened by a sovereign authority, that sovereignty merges into the sovereignty of the Constituent Assembly and it ultimately gets transferred to the Constitution of Jammu and Kashmir. Now therefore you have two sets of documents. Article 371D, if it is deployed in such a manner that it results in the complete abrogation of J&K Constitution, is something which is, in my respectful submission, not contemplated.
All right. What is the next point, Mr. Nafide?
So my next point is, now, originally there were two routes. One was 373 itself. After 1957, that route is closed.
Yes.
Then we take recourse to Article 368. So in Para 7 of the judgment in Sampat Prakash, Para 7 in Sampat Prakash,
Yes.
it was relied upon by Mr. Dave. I don't wish to therefore repeat that.
Para 7 of Sampat Prakash.
Sampat Prakash.
What is the submission on that?
Justice Dave, Mr. Dave said that your lordships in this judgment have recognized that Article 373 is still in force. This is much after 1957. Now that route is obviously closed. But Sampat Prakash goes a step forward and says that even with reference to 368, you can't do it. Para 13. Para 13 of Sampat Prakash, I'll show to your lordship that your lordship will get PDF, Volume 1, PDF 3033. Now, this, in my respectful submission, is no longer good law. in view of what the 11 judgments in Keshavananda Bharati say. Every judgment in Keshavananda Bharati says that every part of the constitution can be amended. Of course, some judgments take a view subject to the rider that basic structure can't be touched. But there is not a single judgment in Keshavananda Bharati which carves out an exception. And therefore, in my respectful submission, the only route which was constitutionally permissible is through 68.
That's what Mr. Dave has also argued.
Yes, that's what. So therefore, to that extent, para 13 of Sampat Prakash is not a good law. But para 7 remains. So therefore the question of what do we do with J&K Constitution? The core provisions, as I said, part 5 and part 6. The executive and the legislature of J&K are created by J&K Constitution. Now, by reference to Articles 3 and 4, by taking recourse to Article 3 and 4, these constitutional provisions contained in J&K cannot be done away with. So, two submissions in this regard. The framers of the Constitution were aware of the fact that the Constituent Assembly for J&K is in the offing, clearly reflected in Article 370. Now, therefore, the question is that does it not contemplate, when it says that provisions, this Article 370 special status, provisions of the Indian Constitution can't be applied unless you follow a certain procedure, does it not contemplate clearly that the Constitution of India, as framed by the Constituent Assembly, recognizes the existence of J&K Constitution? And therefore, doing away with that can only be through a constitutional process. Now, therefore, your Lordship will see that this is a limitation. The existence of J&K Constitution is a limitation both on the power of the President under Article 371D, also the Parliament's power under Articles 3 and 4. So part 6 of the Indian Constitution has never been applied to Jammu and Kashmir, except a few provisions here and there. But the core, the executive and the legislature, those provisions contained in the Indian Constitution have never been applied to J&K. In the judgment in NCT of Delhi versus Union of This is the four characteristics which your lordships have written. In paragraphs 292, 290, 291, 292, 296, 298 and 305. So kindly see what your lordships have said. The framers of the constitution were aware of the challenges which the new instituted democracy could face. In his address to the Constituent Assembly, but kindly come Milord to the straightaway to 305. This is the discussion which I don't wish to trouble you. PDF page 160. There are four abiding principles which are essential to the understanding the content of the Constitution. The first is that as a political document, the Constitution is an expression of the sovereignty of the people. This is satisfied by J&K Constitution because the Constituent Assembly was convened by the Maharaja, Yuvraj, because of clause 8 of the accession. The second is that the Constitution seeks to achieve its vision of a political and social ordering on the basis of democracy. A democratic form of government recognizes that the sovereignty resides within the people. Popular sovereignty can exist when democracy is meaningful. This is also satisfied. The third principle is that the Constitution adopts a republican form of government in which the powers of sovereignty are vested in the people and are exercised directly or through their elected representatives. This is also satisfied. The fourth, which is not the least in importance, in the secular ideology of the Constitution, for it is on the foundation of secular order that freedom, liberty, and dignity and equality to every citizen achieve. Now, if these are the four characteristics of a constitution, then in my respectful submission, J&K Constitution satisfies that. Now, when we talk of sovereignty, it does not necessarily contemplate external sovereignty. I accept that the concept of sovereignty vis-a-vis J&K is not external sovereignty. Because defense, foreign affairs, etc., the subjects were already accepted in the accession treaty. I am not therefore suggesting for a moment that this sovereignty is absolute in the sense in which that concept is understood in international law. I wonder whether even the current scenario under the international law, is there anything called absolute sovereignty? Because there are so many conventions by which the state bind themselves. And your lordships have recognized that your lordships courts can enforce the international conventions, though India may not have ratified them. So therefore, the absolute sovereignty concept, which was some 200 years ago, is no longer exists even in international. But the fact remains that that concept of sovereignty has some content. And that content with regard to Jammu and Kashmir is that their internal affairs be conducted at least in accordance with Part 5 and Part 6 of the J&K Constitution. A 371D can make only marginal inroads. Anything beyond that, which results in the constitution of J&K evaporating, it can never have been contemplated. Now, in the alternative, even if we accept the concept of internal sovereignty, with respect to other states, keep aside Jammu Kashmir, because people get obsessed with the concept of special status. Forget the special status also for the time being. But Your lordships in Bombay have quoted with approval a passage from CJI's book which talks of internal sovereignty. Your lordship may have a look at that para. That is para 97. It is PDF
Volume,
volume 2,
page.
page 113.
Para.
Para 97, sir. Where Sirva has been extensively quoted. Therefore, every state in this country has internal sovereignty.
Para?
Para 97. PDF page 113. Where Sirva has been quoted extensively. I don't wish to read that entire portion. But kindly see B clause, the subpara B on page, PDF page, next page, Your Lordship, 114. The Parliament's power to alter the boundaries of states without their consent is a breach of federal principle. And subpara D, external sovereignty is not relevant to the federal nature of a constitution, for such sovereignty must belong to the country as a whole. But the division of internal sovereignty by a distribution of legislative powers is an essential feature of federalism, and our constitution possesses that feature. Now, if this is so with regard to the other states, much greater weight must be applied to J&K constitution.
Yes, Mr.
So in Santosh Gupta's case, 2017 2SSC, which your lordship will find in volume 1, PDF page 136.
What are you citing it for?
This is because this judgment says that J&K sovereignty has come to an end. Probably the Union of India wants to rely upon that carefully. That is how it has come in the. So I wish to point out to your lordship that what was the issue in this matter? The issue was whether the provisions of the Surface Act applied to J&K or not. There was a constitutional challenge, which was upheld by the High Court. And the High Court referred to in the judgment several times the sovereignty of the J&K. And also said that this does not fall within the list 1. Now this judgment takes a view, if your lordships look at paragraph 43 and 44 at PDF pages 133. That Surface Act falls principally within the provisions of, within the ambit of entry 45 and entry 95, list 1. That's the finding in paras 43 and 44. Now, having come to this conclusion, that since it falls in entry 45 and 95, the list one. The question whether J&K constitution had sovereignty or not does not survive for consideration. Therefore, this is an arbiter. Applying the test which Chief Justice Chagla applied in that Bombay judgment, which incidentally I forgot to refer. It is there in volume 29.
We look at it, yes.
I just read out. So page 5 of that. This is what His Lordship. But the question still remains as to what is an arbiter dictum given expression to by the Supreme Court, which is binding upon the courts in India. Now, an arbiter dictum is an expression of opinion or point which is not necessary for the decision of a case. This very definition draws a clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of the case. But in both cases, points must arise for the determination of the court. Two questions may arise before the court for determination. The court may determine both, although only one of them may be necessary for the ultimate decision of the case. The question which was not necessary for the determination of the case would be ratio decision. The opinion of the tribunal on the question which was not necessary to decide would be only an arbiter. I don't think that this view can be found fault with. So therefore, in para 47 in Santosh Gupta's case, His Lordship says that sovereignty has come to an end. In the first place, this is clearly contrary to in Premnath Kaul's case, which has been cited by Mr. Dhawan. I just want to show to your Lordship only one observation from Premnath Kaul's case that your Lordship will find. That is para 16 of that judgment. What is the PDF page? Well, second line from the top, we have no doubt that the Yuvraj was perfectly competent to issue the proclamation of 20th April 1951, under which the Constituent Assembly ultimately came to be elected and convened. If the Constituent Assembly was properly constituted and it decided not to pay any compensation to the landlords, it is difficult to understand how the validity of these decisions can effectively be challenged. Your Lordships have specifically recognized the power to convene a Constituent Assembly. That's an act of sovereignty. So there is one more para. He has read para 42. Who has read? Yeah. I'm sorry, I read para 42, not para 16. I stand corrected. So therefore, in my respectful submission, the observations in para 47 in Santosh Gupta's case to the effect that the sovereignty has come to an end is clearly contrary to Premnath Kaul's case. In any case, it's an arbiter. In any case, there is not much of discussion in that judgment on this issue. And it's a judgment of only bench of 2 learned judges. So my next point is Article 356. Much has been said by Mr. Dave and others, but there is one aspect which I want to bring to your highlight. It may be an overlap, but there is particular aspect which I want to emphasize. What is the effect of the presidential proclamation? So kindly turn to Article 355. What is the purpose of 346 or 356? There is breakdown of the machinery, accepted. The affairs of the state cannot be carried on in accordance with the Constitution, accepted. But does that justify doing something which is unconstitutional? So in the first place, the J&K Assembly was dissolved in November 2018 and the governor assumed the powers. He assumed the powers under the J&K Constitution. And not the 356 proclamation came in December 2018. This presidential proclamation under 356 is clearly without jurisdiction. Clearly without jurisdiction. The reason is that the governor has already dissolved the assembly. The governor has assumed all the powers of the state. Now, certainly the governor assuming the powers can't be a breakdown of the state machinery. It would be absurd to suggest that, and therefore President has to intervene under 356. It's a jurisdictional issue. And 356 has been invoked for a collateral purpose. And that collateral purpose is apparent on the face of the record. You suspend the two provisos to Article 3. The first proviso which applies to all the states, that you can't alter the boundaries, change the name of the state, etc., without first giving an opportunity to the state concerned to express its views through its legislative assembly. You suspend that. Second proviso which applies to J&K without the consent of the legislative assembly of J&K. Now I cannot understand if there is breakdown of the machinery, what is the necessity, what is the rational nexus to suspending these provisos? There is an implied limitation on this power. Can you suspend the entire constitution? Because the president has issued proclamation under 356. Once you accept that there are implied limitations, the suspension of any part of the constitution as a result of presidential proclamation under 356 must have a rational nexus to the objective that is to be achieved. And the objective that is to be achieved is Article 355. Kindly see Article 355. The duty of the center. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Now read Article 355, 356, 357 conjointly. And the only result is that the state as an constitutional entity must survive. Now, what is the purpose of suspending the proviso? Ultimate design is abolishing the state of J&K. Contrary to the mandate of 355. Therefore, your Lordship will see the J&K Reorganization Act is born, is conceived in an unconstitutionality. Patent. Now let me test even the wording. I have shown to your Lordship the context, but kindly see what 357 says. Sorry, 356C. Make such incidental and consequential provisions as appear to the President necessary or desirable in giving effect to the objects of the proclamation. Now, suspension of those provisos, what is the nexus? In the entire affidavit of the Union, I don't find any light being thrown on this aspect of the matter. Then kindly see 357. (357) 1B. For Parliament or for the President or other authority in whom such power to make laws is vested under subclause A to make laws conferring powers and imposing duties or authorizing the conferring of powers and the imposition of duties upon the Union or officers and authorities thereof. Now this is a power to make law. The way Dr. Dhawan, everybody has argued that 356 is a temporary thing. This, that the power or the function that the state assembly performs under the provisos to Article 3 are not power of making law. Article 357, 356, they refer to the state legislature's power to make law, which is taken over by the Parliament or by President by issuance of ordinance. But this is not that power. The power under proviso is not law-making power at all. And this is recognized by judgment in Keshavananda Bharati's case. Again, I have to refer to Justice Khanna's just observation. And that is para 1351, which volume 15, PDF 542. So this is with reference to proviso to Article 368. But the logic would equally apply to proviso to 3, Article 3, my submission.
And your argument is that 357(1)(a) provides for Parliament to confer on the President the power of the legislature of the state to make laws.
Make laws.
And that function which you discharge under the proviso to Article 3 is not the power to make laws.
Power.
We got it.
Not lawmaking power.
We made the point.
Yeah.
What's the next?
So therefore, it can't get, the President can't take over that power.
Just give us the
1351.
volume.
1351. Articles 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of states.
What is the PDF page? PDF page?
542.
Yes.
Article 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of not less than one half of the states in respect of certain amendments, the constitution would be meaningless because there is no question of ratification of a legislation made by the parliament in exercise of the powers conferred by Article 248 read with entry 97 list 1. It is noteworthy that the ratification is by means of a resolution by the state legislature. The passing of a resolution can plainly be not considered to be a legislative process for making a law. The state government also do not come into the picture for the purpose of ratification, etc. So therefore, your lordship sees that everything that the legislature does is not necessarily law-making process. So therefore, the powers under the proviso would have never been taken. So therefore, Article 356 proclamation suspending those two provisos which have no nexus whatsoever to the object to be achieved under 356 clearly collateral. So now I come to interpretation of Article 3 and 4. So the reference I made to Article 355, but some passage from Bomai I must show to your lordship. Para PDF page 155
Of?
of volume 2. Now kindly see what that para says. This is with reference to Article 355 on which I place reliance. That the purpose of 356 is to restore the state. Para 160. The crux of the question.
Just 1 second, which page are you reading? 155.
The PDF page 155.
Which judgment is this?
Bomai.
Volume 2. Para 168.
Para
160.
160. I think judgment of K. Ramaswamy. The crux of the question is wields of the President's power under Article 356. This has a direct bearing. It finds its birth from a family of emergency provisions in Part 18 of the Constitution. Article 355 imposes duty on the Union to protect states against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. As a corollary, when the government of the state is not being carried out in accordance with the provisions of the Constitution, a constitutional duty and responsibility is put on the Union to set it right. So therefore, if the machinery has broken down, to set it right means to see that the state normalcy is restored. So therefore, Article 356 cannot be read in isolation. The purpose of 356 is to restore under Article 355. That's the purpose for which. Now, another reason to say the same thing is said by Justice Jeevan Reddy and paragraph 272 and Justice Sawant at para 56-57. I did not read those paras, I'm just giving to your lordship those parameters. So the sum and substance of BOMA is this, that restore the state to normalcy because that's a duty cast upon you under Article 355. Now there is one more reason to say that the exercise of power under 356 is for a collateral purpose. Because ultimately what they want to achieve, get away with, do away with Jammu and Kashmir state. That point I already made. I have also said no jurisdiction because the governor had already assumed the powers after the assembly was dissolved. There is one more reason which is to be found in judgment of this court in K.N. Rajgopal versus Karunanidhi. 1972, volume 4 SCC, page 733. PDF page 68-69.
Of which volume?
So PDF page 68-69, volume 19. It's a one-page judgment, but has seminal contents.
Volume?
19.
Paragraph, there is only one-page judgment. It is volume 19, PDF page 68-69. So this is what your lordships have said. We have just delivered a judgment in so and so. A similar question arises in this appeal, but with respect to the Chief Minister and the Minister of the State of Tamil Nadu, the relevant articles are worded similarly. The only difference is that the governor is not elected, but is appointed as the president under Article 155 of the Constitution and under Article 356 of the Constitution, makes a provision in case of failure of constitutional machinery in the state. But when an assembly is dissolved, there is no failure of the constitutional machinery within Article 356, Article 164, which provides that the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, has to be read in Article 75(3). Following our reasoning in that appeal, this appeal was successful. In other words, what your lordships have said is that once the assembly is dissolved, there is no question of machinery having failed, and therefore, consequently, there can't be a 356 exercise. So in this context, I invite your lordship's attention to judgment in Gujarat Assembly case. Now, if your lordships have a look at Article 356, there is no provision which says that what is the upper limit. How long you can do away without an elected government? This question came up before your lordship in Gujarat Assembly case. And your lordships have said 6 months. I just said that judgment is in volume 19, PDF page.
Page? Volume 19 page?
Does it?
Page, volume 19 page?
I'm just reading. Page 283. Which is the panel?
Volume 18, page 283.
So kindly come to para 79 on PDF page. The PDF page. 283, sir. 283. Para 79. However, we are of the view that the employment of the words and expiration occurring in section 14 and 15 of the Representation of the People Act respectively show that the Election Commission is required to take steps for holding elections immediately on expiration of the term of the Assembly or its dissolution, although no period has been provided for. Yet, there is another indication in section 14 and 15 of the Representation of the People Act that the election process can be set in motion by issuing of notification prior to the expiry of 6 months of the normal term of the House of the People or the Legislative Assembly. Clause 1 of Article 172 provides that while promulgation of emergencies is the operation, Parliament may by law extend the duration of the Legislative Assembly not exceeding 1 year at a time, and this period shall not in any case extend beyond a period of 6 months after the promulgation has ceased to operate. Further, under Article 123(2)(1)(3) of the life of an ordinance promulgated either by the President or by the Governor, as the case may be, is 6 months, and repeated promulgation of ordinance after 6 months has been welcomed by this court. Again, under Article 109, 110, and 111, and analogous articles for the State Assembly, money bill has to be passed by the House of the People or by the Legislature. So the period of 6 months has been read by your lordships. Then there is one more para of in the same judgment. This was of Justice Khare, and there is para 147 in the judgment of Justice Prasad. PDF page 316. So this is the ratio. Para 147. Almost his lordship has echoed what Justice Khare has written in the 79 which I read out. Now I come to Article 3 and 4. Now kindly see the marginal heading. Formation of new states and alteration of areas, boundaries, or names of the existing states. This is a clue. Of course, there is a debate whether marginal headings can be seen or not. But fortunately for us, this issue is no longer res integra, as a constitution bench judgment of this court in Bengal Immunity versus State of Bihar 1955 2 SCR, page 603, or year 1955.
What will be the PDF page and volume?
PDF volume 13 and PDF page is 144, and I take straight away your lordship to para 25.
It can indicate the general drift of the provision, but it cannot be used to supplant the actual statute.
That's correct.
The
I'm not
actual
saying-
words of the provision.
I'm not saying. If there is some ambiguity, and there is in my respectful submission, according to me, there is not even ambiguity, there is a conscious omission in Article 3 as regards power to abolish a state. Conscious omission. So why do I say there is a conscious omission? Not only from the marginal heading, but also look at the text. Form a new state by separation of territory from any state, or by uniting two or more states or parts of the state, or by uniting the territory to a part of a new state. Minute details, what that power is. Then it further says, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Details are given. What is the extent of that power? There is no ambiguity at all. There is not even a whisper about abolishing a state. And this has to be seen in the light of Article 1. India, that is Bharat, shall be a union of states. Two also. The Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. So Article 1, India, that is Bharat, is the union of states. Article 2, admission of new states. Article 3 gives details of the power that the Parliament has. Now, therefore, there is a conscious omission to abolish a state. My second point.
What happens when you unite two states?
But the point is this, your lordship will see that a territory, what is the idea behind the state? That people in a given territory should have a state government. Two-tier democracy at the state level, and that is how the constitutional scheme is. Some powers are given to the state, list 2. They have their own government. So this concept of a state is inbuilt in a democratic structure that this constitution has built. In other words, the existence of states is a part of the basic structure. And J&K can't be an exception to it. Then why not tomorrow abolish Bengal? By what parameter? That according to me, there is a conscious omission. So Article 1, 2, 3 have to be read together. Now, there is one more reason. This alteration of boundaries, changing the name of the state, uniting two states, one state being divided into number of states, this does not amount to an amendment of the Constitution. True. So all the more reason why this power must be narrowly construed. According to me, no two interpretations are possible. There is a conscious omission to abolish a state because India is the union of states. I link it with 355 and 356. Article 3 has to be read with 355. If there is breakdown of machinery, restore the normalcy. But you can't abolish a state. And since it does not amount to a constitutional amendment, it must be strictly, narrowly construed. And this interpretation, in my respectful submission, would advance the concept of democracy and concept of federalism. open the Article 18. Article 18. Of my argument. Now forget everything. What is the impact on the constitutional structure where everything has been turned upside down? First, what is the impact? Ladakh under the reorganization has no representative in the Rajya Sabha. People of Ladakh therefore do not count as far as Rajya Sabha is concerned. So much for the democracy. Now look at Lok Sabha. All existing Rajya Sabha. All existing 4 seats in Rajya Sabha go to J&K. Ladakh is left out. Consequently, people of Ladakh have nothing to do with working of Rajya Sabha, including the election of the deputy chairman under Article 1989 and 90. Second, look at Lok Sabha. Under Article 81C, all union territories in the country can maximum have 20 seats. In that, you have the J&K. But look at the discrimination. Under Article 81, Clause 2, as far as other states are concerned, the number of seats that they have depends upon their population. And the Constitution further mandates that this ratio between the population and the seats for all the states shall be same as far as practicable. So in state of Jammu and Kashmir, irrespective of its population, it has no proportionate representation in the Lok Sabha. Discrimination. Article 14. Now, if you create some more union territories, that limit of 20 will have to be crossed. Today it is 19, including the 5. That's all right. But look, if working out seats for other states is a different formula. How can this be done? Other disastrous consequences. Look at the election of the president. Come to Article 54 and 55. For electing the president, the electorate consists of members of parliament, both Rajya Sabha, Lok Sabha, and also the legislative members of respective states. Now, J&K is not a state. Therefore, there is no MLA for the purpose of president's election. Now, to the exclusion of such a big area, no say in the election of the president, if not by direct, at least by an indirect method. But I must hasten to add that the Reorganization Act says that J&K will have the same rights as Pondicherry. And Pondicherry under Article 54 and 53 there, but this will require a constitutional amendment. You can't do it by law like this. Other disastrous consequences, Article 279A, representation in the GST Council. People of Jammu, Kashmir, Ladakh have no say as far as that council is concerned. appointment of High Court judges. As far as other states are concerned, the governor is one of the persons to be consulted, and governor means aid and advice. So that also goes away. There are several such provisions in the Constitution which are impacted. Therefore, by a very small act which apparently looks constitutional, that is Constitutional Order 272, the whole constitutional structure is demolished, substantially restructured with J&K. So I'm grateful that
Thank you, Mr.
I
Nakle.
exceeded my time.
No, Mr. Nakle. Thank you very much. Thank you, Mr.
And
Nakle. Who will-
both Mr. Dave and everybody has argued that consultation contemplated must be effective. That is why elected. That point has been extensively argued. So I'm sorry that I exceeded my 1 hour.
Thank you, Mr. Nakle. Thank you.
I thought in the circumstances, perhaps I was justified. I am grateful, Mr.
Somebody's time will have to get deducted.
Ultimately, whether it's 20 over, 50 over, the time is allocated to everyone between whatever is available.
How much somebody can bat will depend on the total number of hours.
Since your lordship used the word bat, Lord, it reminds me of my position at this point of time is like that of a night watchman.
No, you're just after tea, actually, so you have a whole session, you can resume.
Which is a very delicate job, night watchman, no? He has to sustain the flagging interest also. But I have submissions on two issues only. One was what Mr. Nafde was advocating just now regarding demolition of a state into union territory. And the only thing I wish to add on what he said was, if Lordship would just have a look at 246(4).
Is it way?
Which matter are you appearing, Mr. Devadi?
Correct number दे दो इनका.
No,
Yeah, it's
in the first matter, Lord, we filed a petition, but we were told to file a intervention application, and then an order was passed on that we will be heard like any other petitioner. Therefore,
So you're for an intervener,
yes.
which just give us just a reference so that, we can, just for the sake of the record, we need to complete the record.
Lord, it is writ petition number. It is IA number 145.
IA number?
2.
Sorry, can you come again, please?
IA number 145
Yes.
852
Yes.
-53 of 2019. This is in writ petition civil number 1013 of 2019.
Actually, 18 forgot to add.
overruling, Lord, inevitably implies that the past practice, whether right or wrong, it will continue to operate and will not be affected by the judgment. But it accepts the fact that if the declaration is made of invalidity of the impugned amendments, then that may have a consequence, and therefore lordships prospectively overrule it. So implicit in this prospective overruling is the invalidity of those supposed invalidity, and therefore lordships try to save it. Now, Lord, another way of looking at it is, Lord, look at it this way. Supposing lordships accept my viewpoint on the basis of the text and the context, and lordships come to the conclusion that yes, there is a case for this, that the power is not available, and therefore the impugned COs are invalid. Now, in order to prevent the effect from traversing on to the earlier ones, your lordship would ask whatever relief lordships can mold under 142, lordship would do that. But that doesn't mean, Lord, that on the basis of this past, Lord, continued exercise of power, your lordships would ignore the Lord text and the context. If the text and the context, as per my submission, inevitably show that yes, the power could not have survived beyond 57, then perhaps, Lord, there is a case to look into it.
All right. Now, Mr. Devadi, should we start with the first point? Because first you have to add on to what has been argued by Mr. So maybe just because we are at about 3:35, so you can maybe in 5 or 10 minutes conclude the first point.
What I wanted to add was, apart from what my friend had said, additionally, if your lordship would just have a look at 246(4). Lordships have had a look at it on several occasions, but then my friend perhaps omitted to see it. 246(4). Parliament has power to make laws with respect to any of the matter for any of the territory of India, which is union territory, not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, that's the inevitable consequence of when you break down the state into a union territory, then Parliament is the sole legislature. Now, when Parliament becomes the sole legislature, Lord, then inevitably, Lord, the state comes out of the federal structure. Because the lordships have said, Article 1, and my friends read some part of it, Lord, I can read some part of it too. Lord, Article 1 says India is a union of state and refers to Schedule 1. I feel lordship would just have Schedule 1 for a moment. Now, Schedule 1, Lord, specifies the states in Article 1 and 4. First schedule. It specifies the states, and Kashmir is there at item 15. And then, Lord, it goes on to have item 2. The lordship would have not 28 states, then item 2, union territories. These are not specified as states. Now, though they are part of territory of India, as per Article 1, yet when it comes to federal structure, Lord, union territories are not part of that federal structure. This is, Lord, there are decisions I have referred to in my judgment, but the decision to that effect, Lord, that Article 1 does not contemplate union territory constituting part of federal structure. And for obvious reason, Lord, if your lordship would recall the definition of federal structure in our constitution given by Dr. Ambedkar, he said there has to be a dual polity. And that is how he declined the entire objections to the Constitution of India as being unitary and not being federal.
Now there is a nuance on that. Following the NCT judgment,
Yes.
We have placed Delhi in a different
And I was coming to that only. Not, it goes further.
position.
What your lordship has said goes further. What it says is that dual polity contemplates that citizen of every state is entitled to be governed by the laws made by two different legislatures. That's the concept of dual polity. Where for local issues, the right is for the local to get himself governed by the local legislature on local issues. And so far as the national issues or bigger issues are concerned, Parliament. That right gets defeated. And therefore, the dual polity gets lost as per Lordship's judgment. States are not appendages, as the Lordship said, not satellites of the Union. They are their own plenary selves created under the Constitution, not the Parliament. So this results in the demolition of the entire dual polity and therefore destruction of the federal structure. And no one can say, Lord, the Jammu and Kashmir did not satisfy the requirement of federal structure. Our federal structure is not defined, but there's an interesting aspect which I wanted to bring to Lordship's notice in this regard. Lord, all throughout, we have been hearing about the quasi-federal character and so on and so forth. It's not truly federal as the American system in our constitution. But in each of these judgments which say so, what your lordship would see is they omit to notice the constitution of Jammu and Kashmir. And when we come to constitution of Jammu and Kashmir, it goes one step ahead of any other constitution. And that is this. It is the constitution of Jammu and Kashmir in our federal structure which lays down the parliamentary jurisdiction. It lays down the parliamentary jurisdiction under the commitment given by the framers of the Constitution and the Dominion of India. It lays down the tone and terror of the state and the union relations. Finally, that's what the framers have said. And then have a look at Section 5. Because if we don't accept this fact, Lord, then Section 5 becomes, which is according to me, the soul and heart of the JK Constitution. That gets absolutely demolished. That's the basic structure of the JK Constitution. And Section 5 says the power of state would be not on any subject which is given to the Parliament. Parliament has been given enumerated powers, that is entry 1 to 96. And not 97 and Article 248. So which means residuary entry is not there. Rest of the entries 1 to 96 are there with Parliament under the Constitution of JNK. The concurrent list and the state list are with the state, except to the extent, Lord, that correspond to the instrument of accession. Now, can you look at this, Lord? Here is a case where the state is going to decide what is the jurisdiction of Parliament and what is the center-state relations, scope of that. So that's the extent to which the autonomy was given to JNK, guaranteed autonomy. And to borrow Dr. Rajiv Dhawan's phrase, Lord, it is democratization of power in India in the shape of autonomy. He referred to various provisions, various levels of autonomy was given. Now, here is the case where the level of autonomy is stupendously raised. But nevertheless, it is part of federal structure. We can't deny because Article 1 and the schedules say so. But by reducing that state into a union territory, what we are doing is we are bringing it under 246(4). Where the people of the state, both the union territories now will have only one legislature, both for local and the national issues. The right to be governed under a dual polity goes for a toss. And that is how we'll have to see Section 3, Article 3, I'm sorry. Berubari gives a clear indication. I'll show that passage. But that is how we'll have to see. The power is limited. We can't, the amendments that have come is only for a specific object. And the object amendment in the, by adding the explanations to Article 3. They have come for a specific object of overruling the Berubari case to the extent it said that union territory is not governed by. So to that extent they overrule. But the remaining part of Berubari judgment which says that states cannot be, they don't have a territorial integrity, the word used. But then they cannot be, they can be addition to the state, they can be subtraction from the state by giving it to another state. That way, what you are conferring is the dual polity. Whenever you change the territory of the state, you are retaining the dual polity for the citizens. Because from this state, they go to another state where the dual polity continues. But then by demolishing it, what we are doing is reducing and demolishing the dual polity into a unitary system under 246(4). That is what I wanted to add to my friends. And I have in my written submissions, given the host of cases where lordships have said this federal structure cannot be disturbed. This is my written submissions, and this is, I would request lordships to see page 44 and 45 in that regard. 44, 45. This is at page, as my friend corrects me, I have given the internal page, page 40, page, PDF page, no.
The written submission what?
What is the PDF page?
394.
The internal page is 44 and 45. So therefore, I submit with respect, Article 1 completely excludes union territories, and therefore, once you reduce the state into a union territory, you deprive me of my right to be governed by two legislatures. That's the crux of the dual polity. Internal page 44 would be at page 437 of the PDF.
437.
437. And I'm only referring to page 44 to 46, and I've referred to a host of judgments, which lordships are clearly aware of. No? But basically, referring to two last judgments, if lordship would see, at page 46, internal page 46, two last judgments, no? Of which one of the Chief Justice was a partner, 2017, 12 SCC 1, this is general, and then 2018, volume 8, SCC 501, and I have given the paragraphs too.
2018?
2018, volume 8, SCC 501, and I've given the paragraphs also in the PDF.
Yes.
And then there is another page, lordship may have, no? 46 and 47, internal page.
Yes.
That is what I wish to add. No? Now, before I proceed, Lord, there were two issues which were rankling in lordship's mind, Lord, from the very beginning, first day. One was, in fact, two from your lordships, and one from Lord Justice Khanna. Lordship had an issue with regard to sovereignty, and the observation was that once you accede to the dominion of India, you surrender all your sovereignty. Now, lots of things have been, I'm already informed you, just that instrument of accession would not amount to surrender unless there is a merger agreement which says that you merge your sovereignty, as happened in the case of other states, which I will show. the other states had not only not acceded before 15th of August 47, they had signed as a precondition made by the Dominion of India that they will sign the standstill agreement also, which covers the matters of local concern. And after that, Lord, they acceded to the Union of India. Thereafter, Lord, they further, when they merged with the adjoining states, the adjoining provinces, provinces automatically merged, provinces under the Government of India Act, they automatically merged. Indian states merged primarily with the provinces, or they formed their own federation. Then they were directly administered states also. They all not signed the merger agreements with the Dominion of India, conceding all their powers of legislation. And that is why, Your Lordship would see Article 238 was incorporated. Article 238, Lord, expressly applied Part 6 and 7. And of course, consequently, Part 11, which is 245, 246, 254, and so on and so forth, to all the other Indian states. But when it came to Jammu and Kashmir, Lordship would have noticed, note that in 370, clause 1, to 38 is excluded. This is despite the fact, Lord, what is important is this is despite the fact that the Kashmir was placed as a Part B state in the schedule, that point of time when the constitution was enacted.
It's now the new point. It's about 10. Roughly, how long would you take? Because we are starting the new point, the second,
Not more than an hour, no? Not more than an hour.
Could we,
I tried.
could we
But some things have
because
been
we'd
said.
like to conclude the submissions on this side on Tuesday.
Quite right.
Frankly, I'll tell you, now we've got so much of information from you, we'd like to put it to the other side and get
Information
responses. I
overload.
think you have,
No, but my situation is not, I'm like a pariah.
now
Not,
just-
my friends are on different issue. I'm on an entirely different issue.
if you could really put it down in say about half an hour or so, so that we can push through on Tuesday and
I'll try my best.
after Mr. Dwivedi, who will be arguing? Mr. Singh, about half an hour or less. You've prepared your written submission. Your written submissions are there, right? So what we'll do is on Tuesday, frankly, I had not seen your submissions over the weekend. We'll look at your written submissions so that then, you know, your time is then, because we'd be completely ready with your background.
Can I make a request?
Cut it down to half an hour, Mr. Singh. Otherwise, you know, we'll not finish this side on now.
See,
Now,
Mr. Seo Singh, see, Gopal Shankar has been sitting all this time. Therefore, he must now decide who is speaking and how long they are speaking, because the Guarantine will apply on Tuesday, certainly. Therefore, it should not be that one person takes an extra time, then other people don't get a chance to speak. This is the problem.
so therefore, half an hour.
Certainly, it'll end on Tuesday.
And half an hour for Mr. Dwivedi, half an hour for
Supposed to
Mr.
be a
Singh.
liberal time period even by any standards.
And after Mr. Chandra Singh, who will argue? Mr. Gopal Shankar Narayan.
My name has been there after Mr. Singh.
So what we do is, Mr. Dinesh Reddy, Mr. Siu Singh, Mr. Gopal Shankar Narayan, and Dr. Menaka. One second. We are laying down a time schedule. The four of you, between yourselves, please ration the time so we complete your submissions by lunch on Tuesday. And then we'll give a little, another half an hour or 45 minutes to everybody else.
Lord, it will be of great help in reducing my time, Lord. If Lordship would go through during this, Lord.
I think what we'll do is,
then Lordship can put a direct question to me
right.
and ask.
What we'll do is we'll go through the written submissions of Mr. Dwivedi and Mr. Siu Singh, and possibly Dr. Guruswamy and Mr. Shankar Narayan. Any particular aspect of your submission that you would like us to focus on, because now you'd be covering things which are left out by the others.
No, but if I can just make one small submission, if your lordships have noticed, everybody on this side, there's hardly been any repetition or overlap, despite the amount of time that's been taken. And the reason I'll explain why. On day one, I told your lordship the number of pages that were involved. Your lordships have been shown only, I think, about 10 or 5, even less than 5% of the documents involved. Well, the rest of it, I'm afraid your lordship may have to go through. What we are doing, personally, I'll tell you what I'm doing. I'm putting down what I would like your lordships to read on your own, because it's going to take way too much time for me, perhaps, to take your lordships through it. There are, in fact, large swaths of material that needs to be shown, but we don't have the time.
Can I suggest one thing?
Yes.
Without giving us, like a million pages,
Yes.
if you can say by tomorrow afternoon, give to the court master on a piece of paper, what are the specific aspects you would like us to, from your submissions, as Mr. Dwivedi has given us,
Yes.
just highlight that. I'll circulate it to all my 4 colleagues,
Yes.
so that then we know exactly what is the area you're focusing on. So we'll be also ready over the weekend. We have those 2 days apart from the Monday reading. We'll focus on that. So we'll get through with the submission, so that will curtail ultimately the time which all of you are. So we proceed on the basis then that Mr. Dwivedi, Mr. Chandra Singh, Mr. Gopal Shankar Narayan, and Dr. Menka will conclude.
After that, probably my turn was there, then I think we've all been locked in.
All right, you tell us. No, all right, you tell us what is the sequence now.
I'll take half an hour.
No, it's.
Parag, the sequence can be, that is why I said Mr. Gopal Shankarayan can put down, you have so many minutes in Tuesday. How much minutes will each of you take? So that it should not be that anybody is left out by the end of the time.
So, Mr. Shankar Narayan, what you can do is, we are concluding this side completely on Tuesday. Please sit with whoever is in the court. You give us on Tuesday morning the sequence and allocation of time, so that we strictly stick to the time, and we conclude on Tuesday at 4 o'clock.
Suggest that I go last if I'm the one doing that, because I don't want there to be any allegation that I favor.
Oh, no, not at
I'll
all.
go last.
I don't think anybody will do that. You've been there sitting there, and you've been making notes and assisting everyone. But now when your turn comes, but give us that on Tuesday morning upfront, so that, in fact, if you can ideally give it to us tomorrow morning, give it to our Mr. Sanjay, our court master. I'll circulate it to all my colleagues. So we know Tuesday morning, and then we keep to that order, the sequence and the time. So there's, everybody feels that, they have.
It's also given slack.
Of course, no difficulty. Absolutely no difficulty at all. Just
If possible, I'll mention the issue.
you can even mention the interveners. Who are the interveners? Between the interveners, no difficulty. You can just right now sit with Mr. Shankar Narayan for 5 minutes after we rise, so that he can just prepare the blueprint for us.
I'll do that.
Please, one thing, this is a little bit of, self-restraint. We'll give 10 minutes, but 10 minutes provided you're saying something which is different from what somebody has argued, then don't cover the same territory. We had that, we still have it, but now we are towards almost the concluding stages of the argument. So now everybody, each one of the council following knows this is the time stipulated, and so that, we conclude on Tuesday. Otherwise, what will happen is the last 2 or 3 council will have very little time left. That should not happen. Like to ration out time for everybody, including the interveners. Mr. Shankaran, just do that, and if you could kindly give it to Sanjay by tomorrow morning, so he'll have it. Thank you.
Yes.